One in 4 of us will fall victim to crime over the next 12 months. For criminals to be brought to justice, witnesses must be willing and able to give their evidence in court.
It is fundamental to the criminal justice system that witnesses should be free to come forward and should be encouraged to come forward, because if they don't, we cannot have a criminal justice system.
But many vulnerable witnesses never have their voices heard. They are silenced because the criminal justice system is incapable of listening to them.
There are cases where witnesses whose evidence might be incoherent or incomplete, yet what they have to say may be very important. They may, for example, be victims of an offence themselves. Now, why should we simply disregard witnesses who are in that condition? Why should we not have a system which enables them to give their evidence for the court to assimilate?
I like pine chips.
You like pine chips?
Lorna Pink is a speech and language therapist, one of 80 intermediaries registered with the Office for Criminal Justice Reform, who help vulnerable witnesses give evidence.
So the idea is that we'll support whichever advocate at the court, the judge or the police at the investigation stage to be able to think about how they communicate questions in a way that the witness will understand. And then if the witness has difficulties expressing themselves, then we'll look at ways of facilitating their answers so they can give their evidence as coherently, as accurately and concisely as possible.
In 2004, 21-year-old Jenny was raped. She suffers from a rare medical condition and learning difficulties, which means she has problems communicating.
Her speech can be unclear when you don't know her. This is because some of the sounds are difficult for her to say. People who know her well don't have that problem, but obviously any jury or judge isn't going to be very familiar with the witness, so it was important. It was absolutely transparent what she was saying for all involved.
A range of vulnerable witnesses are entitled to use an intermediary, either during a police investigation or a trial. Anyone under the age of 17 years old is eligible for assistance. So too is anyone with a mental disorder or learning disability, or a physical disability or disorder that can make it hard for them to understand questions or communicate answers. Both prosecution and defence witnesses are eligible.
An intermediary gets involved in the process by a call basically from the OCJR, where they will have matched an intermediary's skills and knowledge to a witness that requires an intermediary to work with them. Having done your assessment, you then come up with recommendations about how we can facilitate that witness's understanding of questions, ability to concentrate and their ability to express their answers in a clear and coherent way. And then that is discussed with the police officers at the investigation stage before the investigation interview takes place.
Detective Constable Stuart Codlin, who is based in Oxford, has had first-hand experience of how useful an intermediary can be during a police investigation.
We received a complaint through a mother of a 5-year-old that he'd been sexually assaulted by his neighbour, who was a 12-year-old boy at the time. This was last July. And so it kind of got rolling from there. Obviously the ages of both boys meant that it was quite sensitive and very hard to deal with.
The first interview with the 5-year-old victim didn't go well.
I live in a cardboard.
There were 2 rather large red comfy chairs for adults, and the little 5-year-old was totally swamped by the chair and completely lost. There was a live link from that room down to a room below, and you could see from his responses and or his lack of response that he just wasn't comfortable, he wasn't communicating, there was nothing really coming from him of any evidential value. So in terms of forwarding my investigation, it was next to worthless, really.
But Stuart wasn't ready to give up. He called in an intermediary after hearing about the scheme from a colleague, and the results were immediate.
The second interview was completely different. The setup was taken down to his level. The chairs were removed, replaced with large bean bags. The interviewer and the intermediary and the 5-year-old sat on the floor. Toys were introduced, and it totally changed him, his reaction, his communication level, and he gave full disclosure about the offence in that, and meant that we could take it forward.
And what team do you support? Do you support
Liverpool.
Do you?
Without the intermediary, we wouldn't have gone any further than this is going nowhere from the CPS. So yeah, the fact that we got to court and we were able to progress it that far was purely down to their intervention.
CPS lawyers like Luke Bulpid are now getting involved at a much earlier stage in the whole judicial process. And so, with the help of their police colleagues, they are in a much better position to identify when an intermediary could help bring a case to trial.
The CPS are now responsible for the decision whether or not someone gets charged, and this for us as CPS lawyers puts us in the police station and involved in an investigation at a much earlier stage. We're able therefore to identify the need for an intermediary for a witness right at the beginning. We get the opportunity to have a report about our witness which will mould the way that we deal with the witness. We have a person there to help to represent the witness and to ensure that they give their best evidence. It can only help us.
The intermediary scheme has been introduced by the government under special measures provisions made in the 1999 Youth Justice and Criminal Evidence Act. Deborah Gould was the prosecution barrister in the case of two severely disabled boys involved in sexual offence allegations. Both victims had severe communication problems and needed an intermediary. She believes that the scheme is most successful when an intermediary is brought in at the earliest possible opportunity.
If an intermediary hadn't been involved, first of all in the police station, I don't believe that the police would have had the ability to have got any account out of the witnesses because they simply wouldn't have been able to understand their speech. There is still a tendency, I think, for people to assume that because they have a disability, they're not able to give a reliable account at all.
In the shower? Yeah. You get in the shower and you wash your hair.
The scheme's success also depends on the expertise of the intermediaries. Each one is selected by an interview panel for their particular communication skills and given intensive training.
Should we turn over and look at some more? Yeah. The people going on the courses had varying degrees of experience of working with the criminal justice system before or not. I mean, everybody had the competencies of working with people with communication difficulties. And so the training did prepare you to go in and work in that setting.
Jenny's rape case was heard at Liverpool Crown Court. Lorna again acted as the intermediary, helping Jenny give her best evidence.
The witness service from the court contacted me and said that part of their role is to show a witness around court before a trial date, so that they know which rooms they're going to be sitting in, waiting in, who's going to be with them, which entrance they're going to come into court, etc. And they understand who's going to be in the courtroom. So I met with the witness service when they were explaining the sorts of things that they normally explain. I was able to facilitate the witness's understanding of that.
Liz Jones works for the witness service and has seen how useful an intermediary can be.
Court environment is a very frightening environment for the majority of people. It doesn't matter how many times you've been into court, it is quite nerve-wracking. So an intermediary for a vulnerable witness is able to make it that little bit easier in that they're not frustrated by the fact they don't understand what's being said. The language in the court is adjusted to meet their needs rather than the witness having to adjust to meet the needs of the court, which they can't do. So the intermediary makes the process much fairer.
Would you say the long ones or short? Short.
When Jenny's trial got underway in Liverpool, she gave her evidence to the court via a video link.
Without Lorna, Jenny wouldn't have been able to do the video link because the judge wouldn't have been able to understand her. With her help, my daughter had a day in court. Without her, the case would probably have been shoved aside.
It is up to the judge or magistrate in any trial to decide whether or not an intermediary can be used. Judge Elizabeth Steele presided over Jenny's rape case.
Their job is to assist the court. It's to assist the witness, but not to assist the prosecution or to assist the defence, depending on for whom the witness is giving evidence. But they're there as a facilitator to ensure that the witness has every opportunity to give their evidence in the best possible manner.
The intermediary is an objective, dispassionate observer, helping the court, acting as an officer of the court, and interpreting what it is the witness is saying. It's no more and no less than that. He does not embellish and he does not reduce. He gives what the witness says.
As a result of Jenny's evidence, her attacker was found guilty and sentenced to 10 years in jail.
It was good for Jenny, because she would have been in even more of a state if he had got off. She now knows he's in jail and there is no way he can get to her. Without an intermediary, her evidence would never have been heard.
I think it's been a really essential special measure that's come in for people like this witness whose speech isn't easily understood by people. It really is an opportunity to have her equal rights and to have a chance to give her evidence in court, and everybody's got a right to that.
If we haven't all got an equal right to justice, then there is no justice. In order to be equal before the law, some people, children, people with learning disabilities, others, might need help to stand as tall as the rest of us. Well, they have a right to that help. We must deliver it to them.